Department of Private and Comparative Law, Faculty of Law, University of Colombo, to deliver the next presentation.
Good evening. So my presentation is totally in a different area, labor law reforms. I will go only to the key recommendations. So the first one is to compel the employers in all sectors, in all forms of employment, to provide written letter of appointment to their workers. But in Sri Lanka, as it is now, there is a legal requirement to give a written letter of appointment under the Shop and Office Employees Act only. But when it comes to many workers in many categories of work and also mainly in the informal sectors are not having written letter of appointments. The second one is to provide terms and conditions of employment for all categories of workers, because in Sri Lanka now, when it comes to the terms and conditions of employment, working hours, overtime payments, holidays and all, we have in the Shop and Office Employees Act, which applies to the employees who work in the shops and offices, and also other workers come under the wages post. But we have many categories of workers who do not come under any of these two. Therefore, to provide terms and conditions of employment to all categories of workers in Sri Lanka. The next one is to incorporate provisions with regard to part-time work and home work, because it is these two types of employments are not prohibited but not regulated by the labor statutes. The next one is to enable the female workers to work in night work subject to their consent and the approval of the Labour Commissioner. As it is now, under the Shop and Office Employees Act, a female worker can't work after 8 p.m. in shops and offices, and also when it comes to the factory workers, they can work only for 10 days in a month, but there are so many other restrictions. The next one is to prevent discrimination in employment in the private sector. When it comes to the labor statutes, we don't have any specific provision dealing with discrimination in employments in the private sector. Therefore, there is a need to amend the statutes to provide mechanisms to prevent discrimination in employment in the private sector. The other one is to prevent violence and harassment at workplaces. When it comes to the labor statutes of Sri Lanka, we don't have any provision in the labor statutes of Sri Lanka dealing with violence and harassment at workplace, including sexual harassment. Therefore, there is a need to enact a legislation to prevent violence and harassment at workplaces. The next one is when it comes to health and safety at workplace. In Sri Lanka, we have only the factories ordinance dealing with health and safety at workplace. But the factories ordinance applies to the workers who work in factories. When it comes to the workers who work at other workplaces, we don't have any labor legislation dealing with their health and safety. The next one is EPF contributions. When it comes to the EPF Act, Employees Provident Act, it provides that the employers will have to make their contributions to EPF only to the employees who come under the covered employments. So there are many categories of employees who are not coming under the covered employments. Therefore, the Act should be amended to remove covered employments and make it applicable to all employees in all workplaces. The other one is when it comes to payment of gratuity, the Payment of Gratuity Act applies to the workplaces where there are 15 or more workplaces. So the act should be amended to apply it to all the workers irrespective of number of workers at the workplaces. The other one is when it comes to many workplaces in the private sector, there the employers pay the allowances, and many of these allowances do not come under the contributions to EPF and ETF. Therefore, the act should be, the EPF Act and the ETF Act should be amended to have a threshold for allowances. Otherwise, the employers pay a large amount of wages or salary in the form of allowances to avoid contribution to EPF, ETF. The other one is when it comes to the employments in the private sector, there is no legal requirement to have a domestic inquiry before taking disciplinary action. But when it comes to the government sectors, it is a requirement in the establishment code, but not for the employees in the private sector. Therefore, the law should be amended to have it a mandatory legal requirement to have domestic inquiry before taking disciplinary action. When it comes to the plantation workers, earlier their wages were fixed by collective agreements. Thereafter, now it comes under the wages boards. But both are unsatisfactory mechanisms. Therefore, there should be a formula for calculation of wages for the plantation workers in Sri Lanka. The next one is when it comes to the domestic workers are not protected by the labor statutes. But they can go to a labor tribunal. That is the only legal provision we have when it comes to the domestic workers. But most of the other labor statutes do not apply to the domestic workers, and they are being exploited. So there is a need to go for a legislation. And also when it comes to the migrant workers, the Sri Lankan migrant workers who work in other countries are very much abused and exploited. But there should be the law should be amended to impose restrictive conditions on the foreign employment agencies to protect the migrant workers. And also I have some other further recommendations when it comes to the employees in the government sectors. For violation of their employment rights, they can go to the Supreme Court and file fundamental rights cases. But many workers, many employees in remote areas can't afford to come to the Supreme Court in Colombo and file fundamental rights cases. Therefore, limited fundamental rights jurisdiction should be devolved to the provincial high courts, in particular with regard to employment rights. The other one is when it comes to the Human Rights Commission. When it comes to employment matters, the employees in the government sectors can go to the Human Rights Commission, but the Human Rights Commission makes recommendations. But the Human Rights Commission Act should be amended to enable the Human Rights Commission to make binding orders. The other one is Sri Lanka has not ratified many important ILO conventions, because I deal with labor law reforms here. So when it comes to many of these important ILO conventions, still Sri Lanka is not a state party to the conventions, in particular the last two conventions, 189 dealing with domestic workers, 190 dealing with elimination of violence and harassment at workplace, and also there are many other conventions which we have not ratified. So Sri Lanka should ratify these ILO conventions. The last one is when it comes to the judgments given by our courts. So the problem is the difficulties in enforcing those judgments in other jurisdictions. But in Sri Lanka, many multinational companies invest in Sri Lanka and employ the workers and exploit the workers and violate the laws. But when our courts make the decisions, but there's a problem in enforcing those decisions or the judgments in other jurisdictions. Therefore, there should be some treaty agreements to deal with those matters. Thank you.